Introducing our panel today. Welcome. So this panel today is about law school to law firm tech skills. Are students going into the legal practice prepared for the workload and lawyering skills, but also the technology requirements that they need to practice effectively? Today's panel is going to discuss what technology training students may be getting and what skills are needed in order to fill that gap. I am delighted to introduce our speakers today. First, joining us from the University of Santa Clara School of Law, Elizabeth Eli Edwards worked in libraries off and on since 1989. She began her career in libraries as an undergraduate student, working part-time for the LA Public Library. After earning her JD, she specialized in law librarianship for diverse firms, including the legal information publisher Justia, Seattle law firm Foster Pepper, the Seattle branch libraries for the Western District of Washington, Ninth Circuit Court of Appeals, and the LAC Group. Joining Eli is David Holt. He is currently a senior research law librarian at UC Davis, where he teaches legal research to both JD and LLM students. Prior to his current position, David was the branch librarian at the San Jose Courthouse for the Ninth Circuit, and before that, he was a law librarian at Santa Clara University for over 10 years. He holds a JD from Santa Clara University and an MLIS from San Jose State University. His academic interests include intellectual freedom, internet filtering, LGBT legal issues, and the preservation of legal archival materials. Our final panelist is Jeremy Sullivan, who is the manager of competitive intelligence and analytics at DLA Piper US. In this role, he provides oversight of the competitive intelligence research functions at the firm and routinely utilizes, leverages, and evaluates business and legal research analytics platforms with an eye toward uncovering knowledge and enhancing the firm's competitive advantages. In the 15 years prior to joining DLA Piper in 2010, Jeremy worked in various research capacities at 4 other Am Law 50 firms. He earned his MLIS from San Jose State University in 2000. Welcome to our panelists. And so before they dive in, I just want to remind you, if you have any questions during the session, feel free to put them in the chat. I'll be monitoring it. You can also directly message the questions to me if you'd prefer that I ask the question for you. Of any of our panelists. And then, as Delia said, the link to the no-call code of conduct is also in the chat. And with that, I will turn it over to our panelists. Welcome.
Great, thank you so much. My name is David Holt. I'm from UC Davis, as Taryn just mentioned. And today we're going to be talking about law school to law firm tech skills. I really hope that this is a collaborative session, that we get a lot of questions and a lot of audience interaction, as I want this to be an opportunity for us to learn from law firm librarians as to what skills are needed in first-year associates so that this can be accommodated by law school curricula. And with that, I want to dive into a discussion about Rule 1.1, Comment 1, which is in our California Code of Professional Conduct. And you'll see that we have followed the trend that has been ongoing for a number of years now, where state bar associations have required that practitioners demonstrate competency in relevant technology that's relevant to legal practice, that is. So the exact language is the duty to keep abreast of the changes in the law and its practice, including the benefits and risk associated with relevant technology. I think California is the 38th state to have adopted a technology competency requirement. We are a straggler in some respects there, but I'd like to talk about how this requirement is going to impact law school curricula and whether law librarians that are working in academia need to take up technology training for our law students. So what tech skills could potentially be included in this competency requirement? Well, I think it's the whole gamut, and that is everything that can be that impacts legal practice that's used in a typical law firm, and that can range from video conferencing tools, file transfer and document management platforms, research and brief writing tools, time tracking and billing software. Are we doing that currently in our law schools? Data security products, word processing, email, and calendaring software. So really it is the whole gamut of technology tools that are commonly used by law firms that are under the umbrella of this new competency requirement. And that is something that law schools need to consider adding to their curriculum. However, there's a significant barrier that I want to talk about to librarians teaching 4-credit courses that are on law tech skills, and that's the US News rankings. US News rankings have recently changed their scoring for how libraries are evaluated for ABA accreditation, excuse me, not for ABA accreditation, but for US News rankings. And there's some controversy surrounding the new changes that have been made. You can see a bit.ly link that, in fact, let me share my presentation with you. And I'm going to share this in the chat so that everyone can see the article that I'm referring to here. Oh, that's not it. Because I'd like you to look at this article that was recently published in TaxProf blog, and it was written by 3 law library directors, all serving ABA accredited law schools, and their concerns about the US News rankings component for libraries. You can see that the score now is 1.75% of the overall score, which is an increase from what it was in the past. So that's good news, right? However, some argue that the consequence of some of these new metrics is a slow stifling of innovation. Rather than encouraging, this is their language, rather than encouraging libraries to meaningfully contribute to their law schools and help students meet these goals, these metrics continue to reinforce outdated modes of operating, collecting titles, for example, adding seats to the library, and opening library spaces just in case, and are limiting us from aligning our operations with our community goals. Apart from this, there's another aspect to the US News ranking score that is creating a problem for librarians that are teaching 4-credit courses. You may have heard if you follow legal blogs or legal news, that there was a change in the US News rankings, their overall rankings, that was related to the library score. Originally, it was 2% of the overall score, and 0.25% of that was library-led courses, library taught courses. Many of these law tech courses that are being offered in law schools are obviously taught by law librarians. You don't have doctrinal or clinical faculty that are keenly interested in teaching legal tech classes. You may have clinicians, however, that are teaching legal tech as a part of their clinic, but a lot of this responsibility is going to fall onto law librarians who are teaching both legal research and legal tech courses for credit in their law school. However, because of the recent change to the US News ranking score, we're no longer getting credit for those courses that are being taught. And the reason why is because we had a few law schools that were outliers, that were teaching a lot of courses, and it was impacting the overall score. Well, we can't have that. It was changing the place of some law schools by as many as 6 places. And so the US News changed its rankings, changed its scoring, and removed the credit that librarians were once receiving for teaching these classes. And so I'd like to generate some conversation about these changes, what law schools need to be doing to confront some of these obstacles. And with that, I'm going to pass the baton, so to speak, to my colleague, Elizabeth from Santa Clara Law.
Thank you very, very much, David. So my portion of the slides also addresses the rule change for the technology competency rule, comment 1 of rule 1.1 that ties tech competency to overall attorney competency. And my feeling is it's necessary but not sufficient. Um, it I supported the change. I even testified in front of the state bar task force that promoted actually adopting the rule. But I did it because I believe that professional standards should always reflect our values, and technology as a means of effective lawyering is an increasingly important value. That said, as was mentioned in at least a couple of other sessions, I know particularly during the CEB session, the lunch session today, it was mentioned that lawyers can be very wedded to how they do things if they think they're being the most efficient they can. And if you try to take away their current tools, even if you're giving them better ones, there will be some sort of resentment because you're taking time away from them, you're challenging them, you're pushing them to go outside of their comfort zone. And of course, you can't bill clients for time learning tech or training or that sort of thing. So there was an interesting amount of pushback to the task force regarding adopting this rule, but I'm glad that they did it. That said, if you can advance to the next slide, I believe that for law students, this rule should work more as a carrot rather than as a stick, meaning as much as I like telling my students some really juicy, horrible warning stories, I find that the primary motivator for when they take my class or when they come up to me asking for advice on tech law or tech practice, or when we're just having conversations and they talk about their experiences at summer clerkships, what actually gets them interested is knowing that they can do their jobs better, or knowing that they can be more effective earlier in their careers if they learn how to be more proficient at an earlier stage. And I find that's more of a motivator than, having them threatened with, you will fall behind, you will not be trusted, you may not advance as far. It's more of a carrot versus a stick. And I believe that we need to give more carrots to our law students to show them, doing this will help you as your career grows. And another thing I wanted to address for this rule, if you can advance to my last slide, is that I think there's a gap because there are a number of schools. I don't know the exact count. There are metrics out there for how many places are teaching legal technology, and I believe there is quite a number of programs, whether it's students who are going into clinics, whether it's students who's taking formal tech, etc. And of course, if you go into big law, there's lots of training programs. You have the vendors coming in. You may have dedicated trainers. There's the course of the ProCertis program. A lot of firm librarians provide trainings on particular products. I think there's a gap, however, that solo and small firm attorneys are falling into. They don't have nearly the amount of resources to keep up on new technology, or even to figure out how to advance their knowledge of already existing technology. A little story before I turn it over to Jeremy. I'm on a Slack community that's full of attorneys from around the country. And one of them in our channel for legal tech talked about making a 30-minute video for his associates and legal assistants on how to get the most out of word styles, how to, establish that the firm has a style, it corresponds with their local and state courts, and there so happens this firm is in Alabama, with the necessary requirements for filings and documents that are going to the court. It's captured in the firm style. And unfortunately, he's had associates who've wasted time trying to mimic that style manually. So he created this video and he posted about it. And all of a sudden, I saw all of these mid law and even a few big law attorneys going, you need to, one, share that with us because we want to know how to improve our knowledge of styles. And two, you need to monetize this, and not just in a CLE, because the secret about attorneys is that attorneys don't really pay attention to CLE. They do it if they're very motivated by the subject, or it's the end of the year and they have credits due. And if it's in the year they have credits due, it's just they're not really paying attention. But they really honed in on, oh, this could help me, and this could help me help my partners who know even less than I do. So I think there's a huge market for providing services. And I think the conversation between what law students need to know and what attorneys need to know should be expanded within the library realm so that we're getting input not only from firm librarians and academic librarians, but from county law librarians, as well from government librarians all as well. This needs to be a big conversation, and we need to figure out how can we include the group under the bridge, the people who already graduate from law school and are in practice and may not have a lot of time, but are worried about whether or not their tech skills are up to snuff, and give them the tools and resources that they need to keep up and even advance. And with that, I turn it over to Jeremy.
Thanks, Eli. Okay, so next slide, which is just my title slide. And then actually we can just go straight to the one after it. I was very economical in my use of slides. So we'll just, there you go. My whole presentation comes down to a simple aphorism, which is time equals money. And this is one of the things that I think law students should be focusing on with regard to technology. So what do I mean? Despite some kind of fits and starts of trying to get away from the model, the billable hour still rules everything in the law firm environment. And so the interesting irony is technology is designed to make you more efficient, but with that efficiency, you can cut into the firm's bottom line because you're saving time, and so it's less time that you can bill, right? On the other hand, I've talked to partners who think they're worth every bit of the $900 an hour they charge to their clients, who still don't know how to convert a document to PDF. And so I think to a certain extent, there's an incentive to be less efficient. But with tech efficiency, comes the advantages, and Eli and David both have alluded to them. The more efficient you are with technology, the more time you have to do the practice of law. So, you didn't go to law school to become great at formatting Word documents, but if you are great at formatting Word documents, you have created more time for yourself to practice law, which is what you did go to law school for. The other side of the time is money issue is the inefficient use of technology. And this is of particular concern to incoming first years, because again, as partners are trained to think in 6-minute intervals, they will give you the barest bones description of the project that they want researched and send an associate on their way. The associate is only too eager to help, but the associate is likely going to jump onto Westlaw or Lexis and maybe not understand how charges are incurred in either of those platforms and rack up a $10,000 bill, which the client will then see and recognize that he or she can't charge that in good conscience to the client. And then we'll call the associate into their office and annihilate them. So I've lectured in front of law students before and literally started with the premise that I am here to scare them. And that is because there are databases that seemed free when you were using them in law school that are now going to incur real charges. So how do I want the conversation framed in law school? Well, obviously through the spectrum of time is money. There are reasons beyond the mechanical why you want to be efficient with technology. And again, like I said, the more efficient you are, the better you are at providing legal service, which is why you're doing the job in the first place. Another thing to consider is that whether you're going to be a solo or even a big law attorney, there's going to be more that you have to do for yourself. So the days of I don't need to know how to do that because my assistant knows how to do that are in the rearview mirror. To the extent that even at a firm like mine, you have an assistant, you're probably working around the clock and your assistant is not. And there are going to be plenty of times when you need to do something technology related that your assistant is not available to help you with. So another message that needs to be underscored is you're going to have to do this stuff yourself, despite the whatever arsenal of resources you have at your disposal. You're going to have to do a lot of this stuff yourself. And then again, in the legal research context, I think what I would want first years to come in recognizing is, or having, is the ability to assess tools, to think critically about the resources you have. So in law school, you have access to a suite of tools. When you come to a firm like mine, you have access to 400 times that many tools. So what are you going to do to figure out which of those tools charges back to the clients and at what rate? Which of these tools are geared specifically to your practice area? Which of these other tools will still, even if they're not part of your practice area, will still have relevant information that will help you with your practice? And then which tools not only are going to help you better analyze your client's legal issues, but also help you to present your arguments for what you're going to do to support those clients' legal issues. And here I'm talking about, your analytics products. Another consideration is that if you've seen one tool, you haven't seen them all. So I've worked at 5 different firms, and one of the firms that I walked into was using Lotus Notes for email, and another one was using WordPerfect for word processing. Now, I know those are kind of archaic examples, but that still happens. And you're going to be exposed to tools in law school that you're not going to have access to in the firm, and vice versa. So the idea is not to become proficient at Excel, I would say. It's to become proficient with spreadsheets, because you're going to have a difference. All of these tools do similar things, but there's nuance to everyone. And what's your plan for figuring out what the nuances is from tool to tool, so that you can become proficient with them? Beyond that, once you have a handle on the tools that you have at your disposal at your firm, you have to consider what the client has access to. So an example is Word, where if you go to save a document in Word now, there's like 30 different file formats that you can save that document to. Do you know what the client is using? Because again, if it's 3 in the morning and you're trying to send a crucial document to the client and they can't open it because you sent it in the wrong file format, that's going to be an issue. And then the last consideration I would say is that practicing law now is a business. I mean, I guess it's always been a business, but firm lawyers are reluctant to think of it that way. They think of it as an art or a science or what have you. First-year associates that go into law firms are competing not only with other firms, but they're competing with in-house legal departments. They're competing with alternative legal service providers, and they're competing with, the Big Four and organizations like that. And all of those entities are thinking about the practice of law within the context of business. So it's not enough to understand legal specific tools. You have to understand business specific tools, and you have to understand that the efficiency that you are creating by using these tools and mastering these tools is a business proposition. I just had some kind of, wool gathering that I just wanted to tack on to the end, which, maybe will spur some conversation, maybe won't. But one of the things I was thinking about in the process of participating in this presentation was, are today's law students more tech savvy by default? So much of what all of us do now, I saw that. So Eli will chime in on that. So much of what we do now is infused with technology, right? And I always assume that anybody that's younger than me is better with technology than I am. So are today's law students more willing to experiment with technology, investigate the nuances, figuring out what works and what doesn't, think about it critically, and therefore is selling tech ed an easier sell? And Eli says no. So, but again, that's just one thing that I was gathering with. And then the other thing harkens back to what Eli was saying earlier as well, which is how are small and mid-sized firms going to compete with the DLA Pipers of the world? So as she mentioned, we've got law librarians and we've got IT trainers and we've got self-guided courses and we've got budgets for attending legal tech conferences and this, that, and the other. Firms like ours have dedicated business units that are working on e-discovery and document review. And, the average solo or mid-size or small firm is not going to invest in an AI-infused cloud-based e-discovery platform. So what are the opportunities for law firms on the smaller side to leverage technology more strategically so that, when it comes down to budget, it comes down to goals and it comes down to what the client needs, but are there opportunities for smaller firms that can't just buy everything to use technology more strategically? So I'll leave it there, and I guess we'll open it up for questions.
I would just like to say that I don't completely disagree with Jeremy. I think Generation Z, younger millennials, they definitely are more comfortable being surrounded by tech, but that doesn't mean that they know as much as they are attributed with knowing, if that makes sense. I mean, they're obviously comfortable using Google. They're comfortable perhaps using their phones and tablets for communications, although it's strange, the generational thing regarding using your phone for text versus using your phone to actually call people up. I know tons of attorneys who don't like phone calls, who actually hate phone calls. They see their phone as entertainment machine and texting, as opposed to audio communication. It's a very weird thing. But yeah, I've had students who have gone to summer internships and come back and it's like, oh yeah, they ended up having me train in Word because I didn't know how to use, macros, or I wasn't sure how to set up templates. So I had to do some remedial stuff. And I think that's very true that what they do in college and even what they do in grad school, because especially now with the G Suite workspace, Google Docs is a great tool, Google Sheets, Google Slides, but they don't have the same complexity as Word, as Outlook, etc. And so there are students who may not get that regular exposure to the Office suite because there are now these cloud-based tools. So it depends. On the other hand, at Santa Clara, we get a lot of older students who have PhDs, who have engineering degrees, who have worked in law firms already, maybe perhaps as paralegals, as legal assistants. So we have an interesting mix of new students coming in from undergrad who may not have that tech experience, even though they've lived their life in front of a screen, versus professionals moving in from other areas who have some of that deeper knowledge. And it's an interesting mix.
I think it's interesting, Jeremy, you pointed out that big law firms have access to virtually everything. And so what are we preparing our students for in law school when such a small percentage of our students may be going on into big law careers? Are we really preparing them for practice properly? And what tools should we be using outside of a classroom? Should law schools be subscribing to lynda.com? Should law schools be subscribing to tech training platforms to help prepare students outside of the classroom, outside of a formal classroom setting? I don't know. I mean, that's something that maybe law schools need to think about is what tech training can we do outside of a formal classroom setting?
Happily at Santa Clara, the university actually has a Lynda subscription now. How widely that is disseminated, I tell my students, because I usually actually give them an assignment where I give them the California rules of court that cover things like font and line spacing and the like, and I have them format a document using those guidelines. And I said, okay, if you aren't that familiar with how to do this, you sign up with Lynda, it's free through the university, here's the page, you can, get these videos on, how to do this and then do the assignment. But I don't know how many actually do that. And I don't know whether our legal writing and research people are recommending students who aren't turning in well-formatted documents to do the same.
Eli, you had mentioned earlier that the clinics at Santa Clara are using Clio. You think that that's an effective use of tech training? Yeah, I'm not aware that the clinics at UC Davis are using that. What role does the library have in supporting that in your clinics?
The clinics support themselves in terms of the use of Clio. And it's right now it's the Northern California Innocence Project, and I believe our Entrepreneurs Law Clinic that use it. Our Catherine and George Alexander Law Clinic, as far as I know, does not use it. They might use some other form of time entry, but it's helpful, I think, to get students thinking about, how to keep track of their time, to recognize whether or not they need to do daily time entries versus weekly time entries. Because when you get into that firm environment for the first time, you may overestimate your memory and your ability to keep track of what you've done through the week, through the month. So I think that the clinical portion gives them an opportunity to practice and know how to not only put in the time, but how to explain that time. And similarly, I've not only have my class use Clio, but because we also have access to Firm Central, which is a firm management system from Thomson Reuters. So it's an add-on to Westlaw, and that has a time tracking system. And I've encouraged the various law reviews and law journals to use that for the people who are tracking their hours for academic credit, because we have a minimum limit of how far you need to work in order to get those credits. And so now they put in their hours in this system, which I think is, again, practice for, quote, the big leagues.
I have a question, if you don't mind.
Feel free.
Yeah, so this is directed to David, but I'd also be interested to hear what Jeremy and Eli think about this as well. David, you listed several tech tools on one of your slides. And as we all know, sometimes teaching and time are a little bit limited. So if you were to recommend like one, maybe two of the top tech skills. And again, like I said, I would love to get all three of your perspectives on which of these do you think is the most important for law students right now?
I think it's Microsoft Office would be the number one tech skill that I think practitioners need to have proficiency in. They need to be able to make pivot tables out of an Excel spreadsheet, be able to apply styles properly in Microsoft Word, and to manage an email client, whether that's Outlook or whatever it may be, effectively. And I think that we make some assumptions with our students, and this kind of goes back to how much tech skills are present in our students coming in. I think that we assume that some of these younger people have tech skills that because they're constantly using technology. Social media is not a tech skill from my perspective. So if someone is proficient in social media and that's what they've been doing, that's not an applicable tech skill that's transferable to legal practice. But Microsoft Office is something that a lot of students assume they're proficient in, but they really don't have proficiency in the advanced usage of those tools.
I would definitely agree with David. I think another very important skill, particularly when you're in a firm, is document management, knowing how to use the document management system, knowing how to transfer files safely, being able to work and understand what's going on between, communicating with the client, if the client sends a document, figuring out if it's gotten caught in the spam filter or if there's a problem with the firewall. Jeremy mentioned, making sure it's the right format so that you can read each other's works, read each other's comments, making sure that it is secure, keeping in mind issues around metadata, because metadata is discoverable. So if you're sending things to opposing counsel, to an opposing party, you want to make sure that the file, quote unquote, is clean, is not giving up too much information about what you're doing, that sort of thing. So I would think that's also pretty key. So one thing I tend to do, my second lecture is almost always on security, how to use a password manager, what's the best way to physically transfer files versus digitally transfer files, cloud-based solutions, that sort of a thing.
And I'll chime in for video conferencing tools because we've had the year of video conferencing, right? And law firms have invested millions and millions of dollars in making their offices showcases so the client could come in and see what their dollars are paying for. And then we have 14 months where nobody can go into a physical conference room anymore. So theoretically, we've all gotten really good at video conferencing tools, except we haven't. So just from my own perspective, and I'm not ashamed to tell this story, I got a new laptop a while ago and got all set up with Zoom and installed backgrounds for the firm. And then all of a sudden my camera wasn't working. And I said, that's weird. This is something that I should figure out, and I feel like I have the requisite tech skills to figure out what was wrong with it. And I finally couldn't figure it out. So I emailed the tech desk or the help desk, and they said, have you checked to see if the lens cover's on? I've never had a laptop that has a lens cover. So of course I didn't check to see if it has a lens, if I checked to see, and that's all it was. This new laptop has a lens cover because, you want to keep your video conference private, but I didn't know that. So, I mean, this stuff can still happen. And the formatting's an issue too. I mean, I get emails from vendors all the time. Oh, we're going to do a product demo. Can you use GoToMeeting? And it's like, or some other meeting software that I've never heard of. And, maybe yes, maybe no. So, the getting good with these tools and knowing that not every tool is going to work with every person, although so much of your job is going to be intermediated by video conferencing. Going forward, I mean, firms now are looking at their real estate footprint and saying, why are we paying for these, palatial offices when A, we haven't been able to work in them for a year, and B, we're just as likely to meet with a client who's in Tokyo as we are with a client who's from up the street. So, shout out for video tools.
Mhm.
Great, thank you. And it looks like Lucy has her hand raised. Lucy.
Yes, I actually do not have any academic experience, so I may be saying something that is obvious, but when I was in college, word processing was kind of a new technology, and our professor required that we did our thesis using a word processing machine. And I'm just wondering if it's possible to try and partner with one of the professors so that they require some of these technologies be used for at least one of their assignments. And that way you kind of force people to have to learn how to do it.
I think that's a great idea. But in terms of application, there's some difficulty there. Librarians have very limited influence, particularly over doctrinal faculty in how they organize their course. And so I think that's the biggest barrier there. But yes, I think what Eli had earlier spoken about the use of software in a clinician setting, in a clinical setting, I think that may be the route that some libraries may have to pursue, is that we can reach out to our clinical faculty and see if they're amenable to including some tech skill training in their clinics. I think that would be an easier path for many of us than to try to get doctrinal faculty to include tech training in their syllabus.
Yeah, and I just wanted to echo Jeremy's comment too, that I think the best way to present it is not as Excel, but as, knowing how to use a spreadsheet tool or a word processing tool or an online research tool, as opposed to a brand name, because they do all kind of work alike. And just gives people a heads up that it's the technology they're using, not the product.
Right. And I would
Right.
say, going back to Jeremy's point about students having, that critical ability to understand what a product does, what it means to, what function you want to use it for, etc. I think, unfortunately, because of the big two, and I have absolutely no problems with Lexis or Westlaw, they're great products, but students sort of get beguiled by the prizes and the pizzas and the activities, and they think that that's the universe of legal products. And so trying to show them, one, there's all of these other this other universe of tools is a big thing. And then letting them see, it's like, no, maybe Westlaw is not, even though you're most comfortable with it, it's maybe not the best tool for this particular use. You may need to, go farther. You may need to get some training on this smaller database that no one has really talked about, but it turns out it has exactly what you need. That happens a lot in the law, at least in my law school setting, showing students, it's like, no, you can go beyond these two big databases to find the information that you need. And sometimes these are better, and sometimes, the big two are the best.
All right, it looks like we probably have time for just one more question. David, go ahead.
Okay, I had a kind of an odd thought, and I'm not sure how this fits in, but in the old days, if you were getting a degree in theology, you had to learn German, and you did not go to school, a seminary, and take a course in German. You had to, that was a prerequisite. You had to learn German to go to, and if you're going to be a French literature scholar, you have to learn French. So where do prereqs fit into this, where we require students to have certain prerequisites and not shift it to law school? Because my concern is that students, first of all, we talked about the big two, but I have hard trouble getting students to learn Bloomberg, let alone word processing programs and all this other stuff. So how do we do that as a practical matter? And could I don't know if law schools would ever have prereqs, because in the old days, you get into college, you had to have a foreign language, for example, and then they started taking that away. But how would that be an approach?
I don't know. I think that would be a pretty hard thing to push,
I think so too.
to have law school say, okay, you have a great LSAT score and a great GPA, and you qualify in all these other ways, but you don't have the technical requirements. I remember now. It so happens when I went to library school, I was started looking around the late 90s, early aughts. There were a number of library schools that were looking at information science heavy programs that were starting to require, it's like, well, you have to have a program, you have to have a course in statistics, and you have to know at least one programming language,
Yeah.
which basically delayed my start in library school because I didn't have one or both of those things, depending on what they asked for. Whether or not we want to force students, and I don't think the university would want to limit their options this way,
Yeah.
personally speaking. I could be wrong. I'm not sure that that would necessarily fly.
I just don't
That
know how to
said, I
integrate
think
it.
we can do a better job of assessing students' skills and then providing recommendations if they don't have certain prerequisites.
Yeah.
So again, I think it would be more of a carrot thing as opposed to a stick thing.
And I think
One-
David ultimately fall onto law schools. I don't see a way around that, especially with the change in Rule 1.1. This is going to become, there's going to be pressure on law schools to do check training. My concern is that we only think of tech training as formal courses or as elements in our legal research classes, which has very limited impact to our students. There's a small minority of students that take an advanced legal research course or take their legal tech school offering. And so how many students are we really reaching with even the efforts that are being made? That's one of my concerns.
Well, thank you. Thank you, David, Eli, and Jeremy. We've gone a little bit over time, so I'm going to go ahead and stop us, but thank you.